Community and separate property. In this section, we discuss the assets and debt which are accumulated or spent during the relationship. Community property is property which belongs equally to both spouses or registered domestic partners. Separate property is property which legally belongs to just one of the spouse or one partner. When determining whether something is community property or separate property, go back to the source. If one spouse or partner uses separate property to buy something, the item purchased is also separate property. However, if separate property and community property are combined, the result is community property. Here's a layout which tells us the difference between community and separate property. Community property is acquired during the marriage, whereas separate property is mostly acquired before the marriage occurred. Community property are wages, salaries, tips, and other income which is earned during the marriage, including pensions, whereas separate property would be gifts or inheritances which are made out to specifically one spouse or the other, or purchases which are made with the separate property money from before the marriage. Community property also includes employment benefits, which are based off of work done during the marriage, and any copyrights, patents, artwork, royalties, or other such devices if they are created during the marriage. Separate property, on the other hand, includes pensions after the marriage ends, Social Security, and businesses existing before marriage. Additionally, separate property includes property acquired after a permanent separation. So, when we're thinking of what could be community property and separate property, think about what the source is of that particular property. For example, if it's something which was acquired before the marriage, or something which was acquired after the marriage broke up, then it's likely to be separate property. However, if it's something which was acquired during the marriage or earned during the marriage, revenues, profits, wages, salaries, tips, etc., then it's likely to be community property. Additionally, separate property can become community property if the separate property is gifted to the community. Say one spouse owned a house before the marriage. When the marriage occurred, that one spouse can give that house or that property to the community, which means that it will be given to both spouses, and the property will be held in joint title. In that instance, you have a situation where the separate property became community property. And there are other ways in which you can gift things to the community that would then become property which is held in joint between the two spouses and would then be community. There's another type of community property which I want you to be aware of. It's called quasi-community property. What quasi-community property is it's property which is acquired while living outside of California, but it would have been community property if the couple was inside California at the time. Because different states have different rules regarding community property, there may or may not have been community property in the state which a couple is coming from. When they come into California and they're trying to determine which way the property should go, then the court will look to determine whether or not that property would have been community property if the couple had lived in California and had been subject to California law at the time it was acquired. Prenuptial agreements are written contracts which state the disposition of certain property. They're often used when there is significant separate property on both sides, and so the parties would enter into a written contract stating what was going to happen to each particular piece of property which was separate property of them both. For example, there could be a prenuptial agreement which says that a partner who comes in with $200 million is going to keep that as their own separate property and not contribute it to the community. It's important, if this happens, to keep these things separate and to keep the money in a separate bank account, because commingling the funds with the community could cause it to be a difficult problem when they're trying to dispose of it later. In addition to assets, couples also share marital debts. Just like community property and separate property, we are going to look to the source. When was the debt involved? who incurred the debt, and what was the debt for. When we're looking at when the debt was incurred, we're looking at 4 different periods: before the marriage or the partnership, during the marriage or the partnership, the period between separation and divorce, and the period after divorce. So let's look at each of these individually. Marital debt before marriage, as a general rule, is going to be separate debt. So in other words, spouse 1 is not responsible for the debt spouse 2 incurred before the marriage. However, creditors can go after spouse 2's share of community property, and this can affect spouse number 1. For example, you had spouse number 2 who incurred a large gambling debt before marriage and owed $500,000. So if this debt is going to be collected upon by the creditor, then the spouse who did not incur the debt may say that that spouse belongs specifically to spouse number 2 who incurred the debt before marriage. And this is true. However, it's important to remember that community property is split equally. So if spouse number 1 and spouse number 2 jointly own a home together, then the creditors can go after the part of the home which is owned by spouse number 2. And so this can affect spouse number 1 in that the house might have to be sold in order to pay the debts out of the half that spouse number 2 owned in the home to the creditor. Marital debt during marriage, the general rule is it's community debt. Because spouse 1 and spouse 2 were working together and trying to make their household work or their marriage work, which is what the presumption is, they are both liable for that particular debt. In this instance, a creditor can go after spouse number 2 for spouse number 1's debt, even if spouse number 1 agreed to take the debt in a divorce proceeding or agreed in some other way that they would be responsible for it themselves. This is important because when you get to a divorce proceeding, you get to different contracts between the parties. They're contracts which exist specifically between the 2 spouses or the 2 partners. Creditors don't have to look at those particular arrangements. And so even if a certain spouse said, you know what, I'm going to take on this particular part of the debt, the car loan, for example, a creditor can look at it and say it was these 2 people who entered into this, who had the community debt because they were married at the time, and so the creditor can seek to get compensation from either spouse. There are exceptions to this rule. Exception 1 would be the spouse's debt is of no benefit to the marriage or partnership. For example, you have a situation where spouse number 1 maintains a separate apartment by which, for the purpose of entertaining a mistress or entertaining somebody else. And so the debt of the rent of that particular apartment would have been of absolutely no benefit to that marriage or partnership, so that would be seen as a separate debt of spouse number 1. Secondly, spouse number 1 has separate debt for necessaries of life. So this can be food, clothing, shelter, or medical care. In this situation, even if it is separate debt, there are things that spouse number 1 incurred specifically for spouse number 1 did not benefit spouse number 2 at all. They still can go after spouse number 2. And they can actually go after spouse number 2's separate property if spouse number 1 cannot pay. And the idea behind here is that we want to make sure that both spouses have the ability to pay for the necessaries of life. A couple of special debt rules to be aware of. Number 1 is education debt. So these are student loans, for example. These are separate debts to the spouse who was educated. The idea behind this is that only one spouse actually received the benefit of the education, and likely the other spouse had to sacrifice in some way in order to provide the first spouse with the time, energy, or money that they needed to complete that education. Next, we have tax debt. Tax debt is generally a community debt with a few exceptions. The first is that we have the situation of same-sex married couples or registered domestic partners. In these situations, you have to remember that the federal government does not currently recognize same-sex marriage or registered domestic partners. And so when filing taxes with the IRS, you're not going to be able to say that it is a part of the community, because the IRS is going to look at it and say there's no community there in order for the debt to rely on two individuals. Secondly, we have a situation of the innocent spouse. What the innocent spouse is that one person should not be held responsible for the debts of the other, for the tax debts of the other, and it needs certain characteristics to happen at this juncture. Number one is that there was no joint tax return that was filed. They had to both have filed separately. Number two is spouse number one had no reason to know that spouse number two did not report a certain income. Perhaps spouse number one didn't know and had no reason to know because they didn't know or had any reason to know that any income was actually coming in. Number three is the unreported income was spouse number two's separate property. It didn't benefit the community. It didn't come into the community bank account. Hence, there was probably no way that spouse number one would have known about it. Number four is spouse number one received no benefit from the unreported income. And number five is it would be unfair to count the reported income against spouse number one. This is going to be something which will be determined by the court. So these are arguments which would have to be made on behalf of the innocent spouse, and the court would make a determination. Debts incurred between permanent separation and divorce, the general rule is that they are going to be separate debt. In that time between not knowing whether it's going to be a trial separation and a permanent separation, we're looking at community debt. But after a permanent situation, between that and the divorce, it's going to be separate debt. And after the divorce, the general is separate debt, mostly because the marital debt rules don't apply because there's no longer any marriage to base those debt rules upon. Oh, I have an exception here for necessities of life or necessaries of life, and this is similar to what we saw on the previous slide, for the spouse or the child, but there must be no child support order designating the debt to one particular spouse. Exceptions for after divorce are if there is a court order. Additionally, you want to look out for things for joint bank accounts or credit cards. You don't necessarily have to be married in order to have a joint account, or to have both names as the primary and secondary card holder on credit cards. And so if you have a joint account, even if the divorce is finalized, then that could be seen as community property, or rather property which belongs to both people whose names are on the accounts, or separate debt, community debt, in that it would be debt related to both cardholders on the account, whether they are married or not.